September 2024. My name is Michael Beston, Councillor Michael Beston, and I'll be chairing the meeting this morning. Just introduce the two other members of the subcommittee. On my left, Councillor Julie Jones-Evans, and to my right, Councillor Dave Adams. I'll make the other introductions very shortly. Quick housekeeping, mobile phones to be switched off or onto silent, please. Anyone wishing a comfort break, through the chamber doors, and the loos are to the right-hand side of the lobby. We're not expecting a fire drill today. There are no planned fire drills. So if you hear the fire alarm, please treat it as a real emergency and evacuate the building via the nearest escape route. The nearest route is via the stairs to your left as you leave the chamber or the public gallery. Exit via the door at the back of the building, walk across the inner car park to the evacuation point, which is on the pavement opposite the police station. The lifts can't be used in the event of an emergency. Please do not re-enter the building until you're advised it's safe to do so by a member of staff. Thank you. So we'll go on to the agenda. Item 1, so apologies and changes to membership of the subcommittee. Councillor Quirk can't make it today. And Councillor Dave Adams has stepped in on behalf of Councillor Quirk. Thank you. Item 2 is the minutes of the last subcommittee meeting. Now I'm aware, and I appreciate that both Councillor Jones-Evans and Councillor Adams were not present at that meeting. You've obviously read the minutes. If you're happy to do so, I will sign those minutes off. Is that okay? Thank you. Item 3 is to declarations of interest and to invite members to declare any interest that they may have in the matters on the agenda. Are there any declarations? Councillor Jones-Evans.
Chair, it's a non-pecuniary interest and a very light interest, but I thought I'd just to declare it for transparency that I'm a director of a company that has a premises licence in Sandown.
Thank you very much. Nothing from me. Thank you. Item 4, urgent business. Are there any items of urgent business? I don't believe there is today. No. Okay. Item 5. The reports of the Strategic Director of Community Services. Application for a premises licence, the Lounge, 40 Birmingham Road, Cowes, Isle of Wight, PO 31 7BH. Now, before we go on to that, I will introduce all parties in the room. And please bear with me. To my left, we have Megan Tuckwell, Democratic Services, Senior Planning Lawyer, Jodie Gibson. To my right, Shane Batchelor, Licensing Officer, Andrea Ball, Assistant Licensing Manager, PC Andrew Buchanan, and Daniel Power from Regulatory Officer. Thank you. And the applicant is Robert Botka, have I pronounced that correct? Thank you. And to my left, we have objectors, Mr. David Miller, Mrs. Susan Brown, beg your pardon, Rob Flippard, Marla Flippard, and Peter Morton. Is that correct? Okay, thank you. If you'd like to introduce yourself, that's absolutely fine. Thank you. Thank you very much. Okay, I will turn to the licensing officer to summarise the report.
Thank you. An application for a premises licence was submitted on the 2nd of August 2024 by Loungers UK Limited. Premises concerned is the former Methodist Church located in Birmingham Road, Cowes, Isle of Wight. As part of the 28-day consultation period, the applicant has agreed to conditions with both the police and environmental health authorities. Details of these agreed conditions can be found at Appendix 3, pages 31 and 32 of the report. Aside from the agreed conditions, the applicant has, as part of their application for a premises licence, documented measures that will be undertaken should the licence be deemed granted, which will look to further promote and uphold the 4 licensing objectives. These can be found within the application form's operating schedule, section M, at Appendix 1, pages 24 and 25 of the report. Following the production of the committee report and accompanying documentation, the applicant has provided a further document which was amalgamated the conditions agreed with Environmental Health and the Police, as well as the surviving measures originally contained within section M of the premises licence application form. This document has been circulated to all interested parties prior to the hearing today and is titled Revised Operating Schedule. Within the document, the applicant has proposed a slight reduction in timings for the licensable activity for the sale of alcohol from 12 AM to 11 PM, Sunday to Thursday, with Friday and Saturdays remaining unchanged. Whilst the licensable activity of late night refreshment being reduced to 12 AM from 12:30 AM, Friday and Saturdays, and the removal of late night refreshment as a licensable activity for Sunday to Thursday. In addition to these reductions, the proposed opening hours of the business have also been reduced slightly from 12:30 AM Sunday to Thursday to 11 PM and from 12:30 AM Friday and Saturday to 12 AM. The applicant has also proposed that the use of the outside seating area located at the front of the premises be restricted to 10 PM Friday and Saturday as opposed to 11 PM. The use of the outside area for Sunday to Thursday is proposed to remain the same, that being 10 PM. Following the 28-day consultation period, 16 valid representations remain outstanding. To summarise, concerns raised state that the granting of the premises licence as per application and agreed conditions between the applicant, Environmental Health and Police will be likely to have an adverse impact upon nearby residents with regards to noise disturbance from both within the internal and external areas of the licensed premises, as well as the likelihood of disorder and antisocial behaviour from customers of the business as they leave the premises to which the application relates to. Additional concerns from a public safety perspective in that residents would not feel safe in their homes or when passing the premises have also been raised. Details of all concerns raised can be found at Appendix 4, pages 33 to 46 of the report. Following the review of the committee report, as well as considering relevant views from all parties that we raised at the hearing today, the options open to the subcommittee will be to grant the licence as per application, grant the licence with agreed conditions, as well as any additional measures that the licensing subcommittee deem appropriate and proportionate to promote the licensing objectives, or to refuse the application. Thank you.
Thank you very much. Before we go on, I will need to confirm some items that unfortunately I left out before Shane done his introduction. No party has the absolute right to cross-examine any other party. The hearing should take the form of a discussion led by the authority, and cross-examination shall not be permitted unless the authority considers that it is required for it to properly determine the representation's application's notice. An equal maximum period of time will be given to the parties in which to present their case and provide any further information considered relevant to the application or to the promotion of the licensing objectives. Persons speaking can amplify their original representations. However, new evidence that has not formed part of their representation may not be taken into account. Thank you. I won't bring in the subcommittee at this point, but if I can turn to the applicant, Robert Botka. Thank you.
Thank you and good morning. Can I just clarify in terms of the time? Is it equal time for applicant and the interested parties altogether, or I know it's going to form hopefully a discussion, but I wouldn't want to be restricted to say 10 minutes and then everybody gets 10 minutes each. So.
We're not subject to the timer,
Excellent.
but obviously you know we have to conclude this meeting in a fairly in a fair way. So I will give every opportunity for every party to speak.
Thank you.
But obviously we you know I'll gauge it and then we go from there. So
Okay.
I'm not going to time it
No,
exactly.
that's good. Thank you. And I would take it that there is no spokesperson for the interested parties. They're all wishing to speak. They haven't appointed somebody to speak. Normally in these cases, you would have one or maybe two people speaking for residents as opposed to everybody speaking, but it's entirely for you to
I will make that decision. I will determine just to cover that off now as regards to objectors. It would probably not be fruitful if there's repetition of the same issue. So if you could keep the issues separate to yourselves, if you see what I mean. So I can't really allow everyone to speak on the same issues, if you see what I mean. That makes sense.
Thank you. And good morning. My name is Robert Botka. I represent the applicant today. Just to introduce the people I have with me. Kaylee Harbison, immediate next to me, is the area manager who will be responsible for the venue should it open. We have Simon Chalk, who is the regional operations manager, and Kate Eastwood, who is the managing director of the whole lounges operation. So I have had one pleasant surprise this morning, which was to see Susan Brown here. We go back an awfully long way. I didn't know that it was this Susan Brown from the papers, but we know each other from 20 odd years ago, I think, in terms of licensing. So it's good to see Susan. And I'm very pleased to that you won't allow her to cross-examine me in any great detail. So moving on to the substance. A lounge have some 240 family diners around England and Wales, and you'll be familiar, hopefully, with the lounge in Newport, Corio Lounge in Newport. So I don't know whether you've frequented the lounge here. So we have 240 lounge diners. It's an informal cafe diner, family diner, with the emphasis very much on food, and the busiest times of day for us being brunch, lunch, afternoon and early evening. We are not a late night venue. I'll address the hours in a moment. I think it's important for today, bearing in mind the representations and the correspondence that I've had with Shane, just to set out what this hearing is not about, we are here for a license application. It's not a planning application. It's not a pre-run of a planning application. It's also, we are not a lands tribunal, and we are not a civil court. So we're not going to be able to go into planning issues, and it does get confusing. And I think Jodie, if I can call you Jodie, probably knows a lot more about planning than I do. But the merger of the relationship between licensing and planning can get confusing for residents. So we are here today simply to ask for a premises license for authority to sell alcohol and limited late night refreshment if we get planning permission, and if all the other legal aspects to our transaction are satisfied. So I'm not proposing to address you in any length at this stage, certainly on suggestions that there are covenants dating back to 1888 on this property. We're not going to be able to determine today whether those covenants exist, who has the benefit of them, who has the burden of them, and whether they're enforceable. With your permission, I'm going to draw a line at this stage, and hope that's not a feature of today's proceedings, because I don't think you as a committee would be qualified, unless I've read it wrong, but qualified to determine the enforceability of those covenants.
You're absolutely correct. The licensing hearing is to determine the license. There's obviously going to be a crossover slightly between licensing and planning, but we're not here to discuss or determine planning issues. So I'm really sorry. So you know, if we can keep it into order. So yeah,
I'm grateful. Thank you. So we would usually have some 25 members of staff at a lounge. We recruit locally wherever possible, so we bring the benefit of employment to a town. We're very excited to come into Cowes. It's got a lovely high street with a number of restaurants, a number of bars, and traditional pubs. The Corio Lounge at Newport has operated for 2 years. We had resident concerns there before we opened. There have been no issues at all since we opened in Newport, certainly none that we're aware of. Our capacity is some 160 inside, with seated tables and chairs outside for a maximum of 50. But it's really important that we don't create the impression that at 11 o'clock or 12 o'clock, whenever we close, there's going to be 200 people at a lounge and then dispersing onto the high street. That's not the way a lounge operates. It's very much a gradual. We tend not to be very busy at night. I sense the question, well, why are you applying for those hours? We've already reduced to 11 p.m. During the week and midnight on Friday and Saturday. We may not even use the midnight on Friday and Saturday. So a license can be umbrella hours. We don't expect to necessarily use all those hours. And certainly this is not a premise where a bell goes at the end of the license for hours and everybody turns out onto the street. I do give a personal experience of a lounge, which is on the high street in Watford, near where I live, where I went for a meal with my partner at 8 p.m. and it was fairly busy when we arrived. We had a nice meal, but by 9:45, we were just about the only people left, sadly, in Cassia Lounge. And that's on the high street where you've got the Wetherspoons and O'Neill's. It's a busy town centre, and we expect the same here. We don't expect to be busy late into the evening. We have no vertical drinking. Sometimes I get a quizzical look on that, and one committee member last week said that we don't want horizontal drinking either. But by no vertical drinking, what we mean is that people are seated at tables and chairs. So when you arrive at a lounge, you are greeted. There will be a member of staff at a table at the door. You're shown to your table. If you are not a technophobe, you would be able to then order your food and drink through the app on the table, or you can order through a waiter or waitress, and then the food and drink is brought to you at your table. So it is not a pub, it is not a bar, and the emphasis is very much on the food. And we do believe we're bringing something different to Cowes. There are really fine dining experiences in Cowes. There are traditional pubs and there are bars, but we believe that a family diner will fit very nicely onto the high street, giving an opportunity for brunch, breakfast, and reasonably priced family meals. So the hours for alcohol, we've put our Sunday to Thursday 10 a.m. to 11 p.m. and Friday and Saturday at 12 midnight. Late night refreshment we would only need then on the Friday and Saturday night, and opening hours to match, but starting at 8 o'clock in the morning so that people could come in for breakfast. New Year's Eve, we've said 2 o'clock in the morning. We may very few lounges open late on New Year's Eve. It's unlikely we'd like that opportunity if there is demand for us to open on New Year's Eve. The outside area, we had discussions with Daniel, so thank you very much. We had a meeting with Daniel on Teams a few weeks ago, and we were asked to amend our application to make tables and chairs unusable by 11. We're happy for that to be 10 p.m. every day, I think. So rather than having 11 p.m. Friday and Saturday night, which Daniel requested, we'll go further than Daniel asked us to do. And so the outside tables and chairs, 7 days a week, to be rendered unusable by 10 p.m. So that's a further concession by the applicants. And I'm also grateful to the time that PC Andrew Buchanan has spent on this matter, and we've agreed a set of conditions which you have before you. So it's a robust set of conditions now. We have a number of resident objections, and we understand the concerns that have been raised. It is a big change going from the Methodist Church to becoming effectively a restaurant. My understanding is that the church has been closed now for some 6 or 7 years. It's had some limited use for meetings since, but basically it is unused, and it runs the risk of becoming more derelict. It's a fabulous building. I'm sure you're familiar with it. The property was marketed. They had sealed bids, and our offer was the preferred option, principally because of our reputation and the way that we manage our premises, but also that it would still be a building that the community will be able to use, rather than it being converted into some totally other use. There was no application, there was no offer, as I understand it, for a community use building. So the Methodist Church wished to dispose of the building, and that is in legals. I'm going to run through most of the concerns that have been raised, and Shane has already said which are relevant to licensing and which are not. Some of them do blur. So the residents, some are affected by noise from the Duke of York, both people and music. They have live music, and I think sometimes outside live music at the Duke of York, which is just further end of the high street. We are not the Duke of York. The Duke of York will have vertical drinking, live and live music. We don't have either of those. So it's a very different operation. So if residents have got concerns about the Duke of York, their attention should be focused on the Duke of York rather than a restaurant opening here. So we will have no live or amplified music. We have background music only and no music outside. So the background music would not be audible to residents even nearby. It's just within the premises. There's been a concern raised about off sales. We have very, very limited off sales. I've had an exchange with Shane about this. So in the very unlikely, it's possible that somebody has a meal with a bottle of wine and they wish to reseal it and take a part consumed bottle of wine home. That's standard for any restaurant to be able to do that. And it's not something that happens often in a lounge, but we wouldn't want to be treated any differently to any other restaurant. And then there would be obviously consumption of alcohol in the outside area, but again with food. So it's very much a food emphasis. There's a concern that the proposed use is not necessary or desirable, and they are not licensing factors. So we don't have to demonstrate a need. We believe that there will be a demand for the lounge once it's open, but that's not a test. That's not something that we have to satisfy you on today, or to try and decide what is desirable to whom. There's a sadness that the premises are changing from a church into a pub. Well, first of all, we're not a pub, and secondly, it's not been used by a church. It's not been used as a church for a number of years, and they can't be compelled to bring it back into use as a church. The church has decided that they wish to sell the building. A concern that the depleted police service will not be able to cope with another licensed establishment. Your expert on policing and crime and disorder is PC Andrew Buchanan, and his objection, as I understand it, is withdrawn, and the police are satisfied with the application as has been negotiated. Then there's a concern about windows, and can understand the concern there. This is where we perhaps stray into planning, but what I will say is that we expect to have air conditioning throughout the premises. So we'll be using the ground floor and the first floor. We believe that we will be able to have the windows closed on the first floor because we'll have the air conditioning. So that should assist, but that's probably a more detailed discussion for another time. I thought I'd mention it because it's in the papers and we understand the concerns. One of the residents is worried about walking a dog past the lounge in the evening. Well, we were there last night, and I think we would have felt more comfortable if there had been some sort of operation going on, rather than it being very dark and in danger of becoming derelict. So we will be bringing the building back to life, and there's absolutely no reason why anybody should feel unsafe walking past a lounge diner in the evening. A concern about parking is not a licensing issue, but we're no different to the other restaurants and venues on the high street. We would expect most of our customers to walk to us. The one-way street, I didn't quite understand the relevance of it being a one-way street, and I was creating any additional danger there. The concern about potential for large groups to be drinking, dining, and partying, it's simply not a description that we recognise from lounges elsewhere. This is not a drinking establishment, and it's unlikely that if you are going out for drinks with a group in the evening that you would choose a lounge to do so. We're not going to be the cheapest alcohol on the high street, and it's not the way that our customers behave. There's a concern, sorry, I've sort of highlighted something that after staff have sent revelers home, it's all about painting this picture that we're going to have large groups of noisy revelers who will depart onto the high street and setting off, creating noise and setting off alarms. The peace will not return until the early hours. It's sort of an Armageddon. This is the worst case catastrophe scenario, which is simply not the reality of how it will operate. And for the planning application, there will be a noise management plan submitted as part of the. If it's not already gone in, but I have seen it, and it forms part of the planning application. The question, planning change of use. Well, yes, there is an application for change of use, and we know that we have to secure that before this matter can go ahead. Residents are saying that this is generally a quiet and peaceful place day and night. That won't change. It will still be quiet and peaceful, but with a fabulous building that's brought back into life. concerns about light pollution, loss of privacy. These are planning concerns rather than licensing. And then a slightly peculiar line that I saw. I don't know who this came from, but don't fall for the applicant trick of rowing back hours and offering conditions. It's not a trick. We have considered the concerns of residents and of course the officers, and we have rowed back on hours and we have introduced further conditions. There is no trick there at all. And it's the normal process of any license application by a good applicant who listens to concerns that have been raised in representations. The restricted covenants I've already mentioned. I'm not going to dwell on that now, but I can come back to you if you consider it to be relevant. I would argue very strongly that they are not relevant to today's proceedings. It becomes a bit more extreme when, and I'm not saying that these things haven't happened, but one of the residences recently dealt with human defecation, public fornication, vulgar obscenities at all times of night. Well, surely bringing this building back into life rather than having a derelict dark. It was very dark when we were there last night, and the sides of both buildings are dark. Surely you want to have a responsible operator that's looking after the building and making sure that these things don't happen. There's a concern that there would be noise from smoking areas. We used to have discussions at license hearings about designated smoking areas. They've really disappeared now. We don't have designated smoking areas. We don't need them. Very few of our customers go out to smoke. And so we think it would be counterproductive to have a smoking area. So there won't be a smoking area. Understandable concerns about the emptying of bottle bins, etc. This is something that is raised quite frequently by residents when we apply for licenses. Kaylee is probably the best person to speak about this, but it can all be kept within. So we can bottle up within the premises, and we would only take waste or bottles out during our opening hours. So during normal hours, so that we're not disturbing the residents with noise early in the morning. So that's how we would practice elsewhere. One of the residents says that a drinking house is a bad idea. Perhaps, but this is not a drinking house. This is a diner. And because then it may impact on safety of teenage children walking by. Absolutely not. This will be a positive. This will be a responsible family dining atmosphere and can only benefit the area. So we have a sensible operating schedule. We are very experienced operators. You can see from the people I have with me today that we are taking the concerns of the residents very seriously. We'd like to engage with them in discussion outside of this room. We'd very much like to meet with them, and we very much hope that notwithstanding the concerns that they have, that they will become our customers and will frequent the premises. I will probably say this again when I close, but it's important for everybody to be aware that the Licensing Act is a fairly permissive piece of legislation. It generally allows things to happen, but it does have a very important sting in the tail, and that is the process of license review. And I know that you know this, but I'm saying this, and I know that Susan knows this, but I'm saying this for the benefit of the room. That and I've said this at every hearing that I've done for lounges, if the description that I'm giving of lounges, that we're giving of lounges, if in fact that's not how we operate and we do cause the problems that the residents are concerned about, we would hope that we'll give direct contact details today. We would hope that they would not contact us, but if we don't deal with those and if we continue to cause problems, then I'm sure Daniel will be on to us, PC Buchanan would be on to us, or the residents have what's called power of review. So they could seek a review of the license, at which point you could revoke the license, suspend it, or add conditions. It's a really important feature of the Licensing Act. So thank you for bearing with me. I don't know how long I've spoken for, but we're very happy to answer any questions. Thank you.
Thank you very much for that comprehensive presentation. So at this point, I will open it up to my committee members. Councillor Jones-Evans, thank you.
Thank you, Chair, and thank you for that presentation there. Everyone who's spoken so far. Just a couple of clarifications. Obviously, very welcome to see there's been an adjustment to the hours. That's extremely helpful. Just a question about the outside area. So chairs and tables are unusable from 10 p.m. Would that mean they'll be brought in?
So we would normally bring them in after we've closed. So we can't bring them in at 10 o'clock at night, but we can make sure that the area is closed off so that they, whether that's with roping or Kelly or Simon, do you want to answer the question?
So normally with things like that, we would stop using the outside area, and then if we're bringing the furniture in, we would stack it against. So then it's just a case of moving it indoors once the guests have left, so that there's minimal disruption to everybody, because obviously all of the actual noise of the movement will have already been done prior and ready for 10 o'clock.
Yeah, thank you. The reason for my question was because obviously that's a good route home from the town centre, and there's late night takeaways around there, so many people waiting. So there's sort of opportunists to sit down and potentially cause a new public nuisance. That was my question. So I'd like that sort of to be sort of borne in mind. Another thing is about you saying not having a smoking area, but presumably is it a non-smoking establishment? So no smoking on the outside area as well. Is that what you're saying?
Yeah, so at the moment, the government's looking at this. But, technically, somebody could smoke outside, but it's fewer and fewer of our customers are now smoking outside. So it's not a smoking area as such.
No, I'm just obviously if you're open after the hour after 10 o'clock, then the people you have got patrons who are smokers. They'll be coming outside to smoke. Presumably, they'll be able to do that, or just
And they can't
completely
sit-
unusable.
Completely unusable. Yeah.
Okay, thanks.
Thank you. Councillor Adams.
It's I noticed you mentioned with regards to bottles being put in the bins or disposed of in normal working hours. Was the normal working hours are quite late in the day. I've had some experience of that. The bottles and the disposal of the bottles can be quite noisy. That concerns me with the residents. I'd like to see something reeled in where like you wouldn't be 10 o'clock in the evening disposing of bottles, because that's quite noisy. Do you want to?
So what we would do is we wouldn't empty the bottles at all in the evening. So it'd be something that we have internal bottle bins. So they would stay in the smaller bottle bins that we would have behind the bar anyway. And then they would be moved. And then in the morning, we could agree a time as in after 10 o'clock or something like that in the morning, that they would then be emptied into the external bottle bins. So there wouldn't be any late night, because you're right, it is very loud when you empty bottle bins. So we would keep it all internally until the following day and then empty them.
You'll have your opportunity to speak, please. Thank you.
So I'm glad Councillor Adams has brought that issue up about the disposal of bottles. I mean, it's great that you want to put, prepared to put a condition of the time when that would happen, but I'm guessing you also have to work with your disposal company as well. So I think, yeah, if that could be during the times when people are up and about and at work, I think that would be very good. And just looking at the plan here, so you've got a store, and is that where I'm not talking about, I know the difference between planning and licensing, so I'm not just trying to get an idea of the routes of the bottles as they and waste as it goes out. So will it be coming through that back area, that store, and then round the side? Is that the?
Got slightly early doors on this, so we would have to.
Yeah, it's just obviously that's a noise nuisance, isn't it? So
Yeah, but it would be any use of those outside bins would be during the day rather than.
Yeah,
rather-
because if it was
rather
coming at
than-
the side, in front of the side, that's obviously less of a journey. I'm just
It's
trying
something-
to be,
something-
just trying to tease stuff out for, because
Yeah.
residents are obviously concerned about this, about noise. So I'm
Yeah.
just trying to work out in my head,
We can, as I said, we obviously we have a number of establishments that have residents around us, above us, and all that type of thing. So anything like that, depending on what time our bin collections would be, we can, as I said, if our bin stores are right at the back, then we can not empty until a certain time and not bring round to a certain time and that sort of stuff. That's honestly not a problem at all for us.
That's really good to hear that you're amenable to work with them in the area, because I just also I am the member for Newport Central, and so I have the Creo Lounge in my ward, and I can say there have been no issues. I have no residents come to me, but obviously each premises is laid out differently, so I appreciate that. You've got a rear entrance there, so that's why I was kind of like sort of just trying to tease this out a little bit more. So thank you.
I'm just looking at your sales mix percentage figures and the sales by session, and that's quite high, 57% food led. But they're obviously figures nationally, I take it. And the sales by session, the post dinner session is quite low compared. It's actually the lowest of all the other sessions throughout the day. They are national figures, so you've obviously done your research to the local area. How would that compare locally to national figures? Would there be any major variance in your opinion?
No, a lounge tends to operate as a lounge. Okay, did you ask?
There is actually very little variance across the country. There are a few sites that have a little bit more late night, and we have a few sites that have absolute zero. So across the board, there isn't a huge amount of variance. Typically, it's 60%. It's 60% food, and the evenings are the quietest session that we.
Just another point on CCTV coverage now, just dipping into the realms of planning. There will be a raised terrace, as I understand, on the outside. I've looked at the planning application, but just to get my head around the CCTV side of it, I'm assuming CCTV will cover that area. And so how will that be managed and reviewed? I.e., if you've got patrons outside, will there be is there a regime to go out and check on patrons, particularly at the night time?
Yeah, lounge have a very long list of requirements of their people for the Katie, I think, will be able to recite them as to how they look after the outside area. They get quite a lot of detail, but really Katie is the best person to answer.
Yeah, because of the way our service is, there's always constantly people moving around anyway. So in that sense of you sort of saying about checking on the people that are outside, there's always somebody moving around. Our natural way of touching tables, speaking to people, obviously clearing tables and that type of thing, with the amount of staff that we would have on, would be doing that. There would be the CCTV, which would then be there if we needed to go back and look at something particularly. But yes, it's not like there'd be an area that's just left. God help them if they left an area dirty. So yeah, it is a case of that it's always under review.
There's an obsession with clearing the tables and making sure the pots are turned the right way, and it's clean and tidy. It's all part of the operation.
Totally understand that, but there is obviously a clear difference between clean tables and antisocial behaviour. So
Absolutely,
need to clarify that.
So lounge, they would be responsible for that area. The CCTV, as I'm sure somebody else will say, is there if something goes wrong and somebody needs to go back and look at CCTV. What's more important is the supervision, that our people will be monitoring that area at all times.
Thank you. Are there any other questions from the committee members? Not at this point. Thank you. Okay, I will turn to the responsible authorities to present their case. PC Andrew Buchanan.
Good morning all. At this time, I've worked licensing now for just under 2 years on the island and had, yes, there's been a couple of instances at the Newport one, but nothing that would cause any concern. So again, I walk past there. I do 2 weekends in a month, So again, I walk past there quite regularly, and again, as they say, their clientele is dwindling as the evening goes on, and never had any problems again with people leaving late. They've answered my concerns with the application, with the concerns of the conditions that they've put in place. So at this time, we have no other objections and fully happy for the licence to be obtained.
Thank you. Any questions from the committee members? No.
Yeah. You mentioned 2 incidents, just what was the incidents?
We had Christmas one. There was one last Christmas where a male got a little bit too rowdy and was then ejected from the premises with no other concerns. They handled that perfectly okay. And I think the previous one, again, was just somebody that was possibly found with drugs in the toilets, and they ejected them and reported it to police, which is a standard across every single one of my venues.
Thank you very much. I turn to Daniel Power, Regulatory Officer.
Thanks, Chair, and morning all. So my comments are not provided to either support or challenge the application, or indeed the representations that have been received, but to provide some justification in respect of the department's position, that being environmental health. So I appreciate the applicant has submitted a revised operating schedule as of the 25th of September, and the Environmental Health Department have considered the application prior to that and have agreed measures for the outside parts. However, in my opinion, having looked at the revised operating schedule, these appear to further safeguard the key licensing objectives, particularly in respect of the prevention of public nuisance objective. So in respect to justification for the original decision to amend conditions, the department's capacity on this occasion to offer conditions is limited, partly as a result of the application not including regulated entertainment, that being namely live or recorded music between the hours of 2300 and 8 AM. As has been mentioned by Mr. Botkai, there is a degree of separation that is required in respect to the premises license application and any subsequent planning application. So I appreciate matters included but not limited to potential nuisances around artificial lighting, commercial odours and mechanical plant noise are by all means taken on board, and however they appear more suited to the planning application process. But I appreciate the matters raised by the residents, and again these will certainly be considered by environmental health in respect to responding to the planning application hereafter. However, today, in my opinion, is a case of reviewing associated concerns accompanying the proposed licensable activities. On that, Part 2.18 of the revised guidance issued under Section 182 of the Licensing Act advises that duplication is avoided wherever possible, especially where there are suitable provisions in other legislation. In this instance, the statutory nuisance regime via the Environmental Protection Act 1990 adequately protects those living in the proximity of the premises in the event of a complaint of disturbance. So the environmental health have that at their disposal in response to a potential complaint. There's also the revised operating schedule further satisfying Part 10.10 of the local authority's statement of licensing policy, given the applicant does not intend on trading during what are considered more sensitive hours, those between 2300 and 8 AM between Sunday and Thursday. And where this does occur with reference to the Friday and Saturdays, the degree of commercial noise activity is to be expected given the mixed use of the locality, which consists of, but is not limited to a neighbouring late night refreshment offer and a late night economy offerings on Mill Hill Road and Shooters Hill. So in addition to submitting the comments on behalf of environmental health, prior to doing so, I reviewed nuisance complaints received by the local authority in respect of the existing commercial premises on Birmingham Road. Now I have to be very careful here because I didn't disclose the figures at the time. So I won't disclose the actual figures, but there was nothing to suggest of any particular concern to environmental health. And what needs to be considered is the addition of a premises that has had 10 temporary event notices within the last year and a half, providing music up to 11 PM, and we've had no complaints as to date. So to reiterate, the department are well placed to investigate complaints of nuisance should they occur. And whilst the department expects to further assess potential nuisance that have rightly been raised by local residents in respect of the planning application that may follow. But at this stage, I welcome any comments from committee members.
Any comments? Not at this stage. Okay. Thank you very much. Thank you. So I will turn now to other persons present to present their case. I believe David Miller.
All right. Firstly, my apologies. My hearing is poor, and unfortunately, I lost a hearing aid yesterday, so my hearing is even worse. And so I apologize if I'm repetitive or mention something which has been covered earlier. I believe this application is wrong, both in the account of the building and the location. I believe the noise will be considerable. I do not believe this is a typical family eating place. If so, why the late hours? Most restaurants in Cowes stop serving at 9:30. And why this very, very long bar in the plan, if all is going to be table service? It's a bar practically the width of the church. I believe the noise will be considerable because it's very difficult to soundproof an old building like a church. I believe that there will be I believe there'll be an emphasis on drinking from about 8 o'clock onwards. Food will be served perhaps there, but the emphasis will be on drinking. And the drinkers will cause noise, both inside and outside. And the hardy drinkers will be drinking outside till quite late because the smokers are very hardy in the Cowes area. And also inside, they will demand music, and you may call it background music. To me, background music is somebody tinkling on a piano. This, to me, is heavy rock, what I hear coming from these establishments. Thumping bass noise. I've heard it in places like this. I haven't been to the lounge here, but I've spoken to people who have been to the lounge here in Newport. As I said, I don't believe it's possible to soundproof an old building, and in particularly churches. Churches were designed to maximize noise. They were designed for hymn singing and plain chant. The shape of a church was designed to create a louder noise to the greater glory of God, as they said in those days. So it won't be possible. Doors will be opening and shut anyway, and in the summer, doors will probably be open continuously. So the noise will percolate outside from inside. There will also be external fans, there have to be. There will be air conditioning, which should be mentioned. Both of these will create extra background noise, particularly reflecting on the people facing onto the church, onto the church at the back and at the side. There will be light pollution as well as the noise pollution. The location is poor. The traffic, it's a residential area. The area of West Hill Road, Beresford Road and Birmingham Road is basically a residential area. There will be extra traffic coming down there. There'll be taxis and people dropping people off at the place. There'll be people cruising, looking for parking places. Parking is already a nightmare. People will not park all the way down in the centre of Cowes. That parking place in the centre of Cowes is very useful for the places in the high street. They won't park there and walk up to Birmingham Road. They will look for parking places in the surrounding streets. And in cases, there will be illegal parking, which will affect emergency services trying to get there. So generally, I think the impact on the residents, who are largely in that area, Cowes permanent residents. These aren't holiday flats and holiday apartments all the way around. There's Cowes residents and many, including myself, retired people living there. I think it's the wrong location. I think it's the wrong building for a drinking place. I would like you to turn this down. We have a surfeit of restaurants and bars already. I know concentration is not a consideration, Doctor, but we do have have a surfeit, and many in the winter are underpopulated, and some even close down in the winter. We don't need another one. I think this will make things worse for the residents on those three streets of Birmingham, Beresford and West Hill Road. And I think it'll make life more difficult for some of the public services in that area. So I do ask that this be turned down. Thank you.
Thank you. Thank you very much. Now, we've got 4 issues there, noise and light hours, parking and competition. Are you happy, Shane, to pick up on the hours? Perhaps Daniel could address the noise and light issues that's been raised.
That's fine. The point that I'd like to make, Mr. Miller, obviously I appreciate your comments, but factors such as parking, location and need aren't factors that can be considered when determining the application. Obviously, those points have been included within the committee report and explanations given as to why that is the case. So from a licensing perspective, the factors that you've mentioned there and which I've just reiterated obviously cannot be considered when coming to a determination. So just need to let you guys know that. Obviously that would have been in my summing up anyhow, but for the information for the other persons that might raise similar queries, they can't be considered.
Did look at the documents you sent me, and it does talk about surrounding area. I appreciate you don't take in consideration, but surrounding area is everything that surrounds the area.
Yeah, without sort of getting into the cross-reference, I just want to say, obviously the guidance relates to immediate vicinity. Now, the immediate vicinity is the premises itself and directly outside of the premises. The guidance also goes on to state that licence holders can't be held responsible for a person's behaviour once they've left the immediate vicinity of that premises. Otherwise, you'd probably have licence holders needing to follow people wherever they went in order to try and maintain the behaviour levels of that person, which it's a decision for that person how they behave once they've left the immediate vicinity.
Okay, thank you very much. I think what I will do is we'll let the objectors speak and then we'll do the summing up from both regulatory and from licensing point of view. So could I turn to Susan Brown, please?
Yes, my name is Susan Brown. I live in West Hill Road. Oh, sorry, do you want me to talk to me? Okay. My name is Susan Brown. I live in West Hill Road. I'm here in my private capacity, not as licensing counsel. I do actually know Mr. Botkai because he used to instruct me on licensing matters many years ago, but I'm not here in that capacity, and I don't really want any reference to that because I'm here as a private individual. I have put in objections to which have been listed, Mr. Batchel. I would like you to take those into account, please. I have put them in writing prior to the hearing. The only way I actually was notified about this hearing was actually from a neighbour, because the application, unfortunately, may have fulfilled statutory requirements. I don't know, but it wasn't well advertised in the community. Just coming back on Mr. Botkai's submissions, he said that the church had been unused for 6 to 7 years. Well, actually, that's not the case because myself and my mother went to church there in 2019. So that is actually within the last 5 years. Obviously, it excludes COVID because everyone was required to socially distance during COVID. The portrayal of it as a building which is derelict and falling down and so forth, I don't accept that. And I don't think the committee should accept it either. A point was made about noise from the Duke of York. Well, the proposal from Loungers UK isn't the same offering as the Duke of York. The Duke of York, though it may have live music, it does have that which is in the premises, has much shorter trading hours than those that are proposed by Loungers UK Limited. And that's an important point. As a public house, they trade the normal public house hours, which is 12, I think, till 11 o'clock in the evening. And then there are shorter hours on Sundays as licensed premises. They don't either do off sales as far as I'm concerned, because as I know, because he is it's a public house premises. It's true that the applicant doesn't have to demonstrate need since the changes brought about by the Licensing Act. But the situation about the building being used for purposes other than a church, this, from my point of view, my premises, my house is probably about, I haven't actually measured it, the tape measure, but it's about 60 yards. It's basically behind the back of the church. You have the houses on West Hill Road, and then my premises is across the road on the other side. My bedroom, the top floor of my bedroom, because I have a townhouse there, so it's a ground first and second floor. The bedroom which I sleep in overlooks the rooftops, you know, from where the church is. So I am in the immediate vicinity. It is very close. I'd ask you to take that into account. In terms of the objectives of noise, there will be, at the moment, the church was used obviously just for Sunday services, and there were certain groups who met during the day, during the week there. Whereas, of course, the use proposed by the applicant is nothing like what was there before. There has been considerable opposition to this application in the community. I think there were 26 objections altogether. It's not really wanted by the community, in my view. Well, as far as windows are concerned, yes, it will provide, that may be a planning issue, which obviously can be dealt with in any planning application. But nevertheless, it will provide a lot of overlooking to those who are behind. My main concern is noise, and also looking at the application. I know I respect you, Chairman, for what you said about the planning and other lands tribunals applications, but being a lawyer, I did actually look at the law. And the land on which the premises is built and the surrounding area used to form part of the West Hill Estate. The West Hill Estate stretched from Birmingham Road up to the end of Concert Road, down to Beckford Road, and then up to Bill Hill Road. And certain covenants were placed on the land preventing a use like this, as applied for by the applicant. I had communications with Mr. Batchelor about this and asked the applicant to produce a copy of the 1988 deed, which effectively means that if you were to grant a subject to the terms of that deed, which I haven't been able to get a copy of, but which is why I asked Mr. Batchelor to ask the applicant to produce it. If you do grant a licence, effectively what you'll be doing is sanctioning a breach of contract of a restricted covenant, because the covenants...
Well, no, it's very important that the committee is not misled.
Just one moment, please. We'll have our chance to speak. Thank you.
The effect, well, I was going to make that point. There is a case, which I looked up, called Lee's application. It is in the Lands Tribunal, where a restaurant licence was applied for, but they went for modification of restrictive covenants first. And the reason they did that is because as licensing justices, because you don't just sit here as councillors, you sit here as licensing justices, you can't be seen to be endorsing effectively a breach of contract of a binding restrictive covenants on the land. If you know, it's, you know, I've done licensing applications in the past where restricted covenants have been brought up, and the licence has been refused on the basis of the fact the land has been bound not to be used for that kind of purpose. Having looked at although I wasn't able to get a copy of the deed affecting for 40 Birmingham Road, the next door licences, and I did send an example of the terms of the restricted covenants binding that area, the general, when the West Hill Estate was set out and the builder was employed to build all the properties in that area, most of which are built in the late Victorian times. A restrictive covenant was placed on, which would prevent the type of application being answered. As far as Mr. Batchelor, my communications with him concerned, it's not a planning matter. A restrictive covenant isn't a planning matter. In order to modify a restrictive covenant, you have to go under Section 84 of the Law of Property.
We are
Now,
now
it's
really
important
into,
because
well, no,
if
no, no,
you,
sorry.
it's important because, and the reason it's important is you can't, as licensing justices, effectively sanction a breach of contract. It would be unlawful. It would be unlawful. So
Sorry,
I'm sure Mr. Botkay can come back in his responses. So that's the point I have to make about that. Submissions were made to you that the church was in danger of becoming derelict. There is no danger as far as we can see. Parking is definitely an issue in West Hill Road and in Birmingham Road. There's a great shortage of it. As far as they didn't envisage large groups drinking and dining because they hadn't had that experience on the mainland. But of course, Cowes holds quite a lot of festivals, and sailing crews do have habits of being, well, I can't say they're loud and noisy, but they do a lot of drinking and dining because you have sailing crews coming down to Cowes all the time. It's that sort of place. Light pollution is a planning issue. I've addressed you on the covenants. As far as I'm sure that Lounges UK would intend to be a responsible operator, but as far as the outdoor areas are concerned, that would produce noise and disruption to the local residents, of which I am one. You know, as I say, my bedroom looks over the rooftops because the amount of all the sorry for Miss Gibson, sorry, I didn't want to interrupt you. All the premises in West Hill Road are 3-storey premises. Most of Corinthian Court, for example, the bedrooms are on the first floor and part of the second floor, depending on how they've laid it out. On my side, all the bedrooms are on the top floor, so they directly overlook and will be disturbed. The moment they don't get that disturbance, because obviously the use of the premises has been as a church. Finally, it was made a point that a licensing application is a permitted application, and there was always an opportunity to review if a license was granted. On that point, I'd say that it may well be the case that there's always been in licensing law, there's always been an opportunity to do a review of a license or object to a license once granted. However, of course, it's far more difficult at that stage to make objections heard than it will be when the license is initially considered. So on the grounds that I've mentioned, I think that the character of the area being residential is a factor to take into account. I have had some discussions with Mr. Batchelor. Mr. Batchelor disagrees with that. He says he tried to distinguish the legal case I sent him on the basis there had been a cumulative policy in relation to a residential area. The fact that there was a cumulative policy in the Guildford case, which I sent to Mr. Batchelor, doesn't mean to say that you aren't entitled to take into account the character of the residential premises which surround this particular area. I would ask that you refuse the application, and there are a number of considerable objections not wanted by the local community. I think that's the bottom line. Thank you very much.
Thank you, Susan. Before we go any further, I just want to get clarity on the restricted covenant. So whether that be you, Shane, or yourself, Jody. Okay, thank you.
Thank you, Chair, and thank you, Ms Brown. I appreciate and understand your concerns and the issues that you've raised around the restrictive covenants on the land. But to be clear that the legal department, and although, yes, I am a planning lawyer, I also cover the regulatory matters for the council as well. When discussed with the licensing team in advance of this hearing, the restrictive covenants on the land are not a matter for the licensing committee. The licensing committee are here to determine the application in accord for the licensable activities in accordance with the guidance on licensing. Whichever way the application is determined, should the license be granted in whatever way, it would then be a matter for the applicant to pursue through other routes, through through civil and through planning to establish whether there were restrictive covenants and how they may be overcome for them to proceed with the business that they want to conduct on this land. Thank you.
Be very, very brief, please. Thank you.
Oh, sorry. Thank you. Oh, yeah, to bring it. Yes, I hear what you say, and I do give you the greatest respect. But the reality is that in this case, as far as I believe it, that 1988 deed will restrict you from allowing 1888 from allowing this land to be used for the purposes sought. And the applicant has had an opportunity to produce it and hasn't done so.
Thank you. Do you wish to respond?
Only say thank you very much. And obviously your views have been noted. And just to reiterate again, for the purposes of the subcommittee here, that may well be the case, that there may be the restrictive covenants on the land. Your purpose here today is to determine the licensable activity. Beyond that, then that is a matter for the applicant to pursue whether they are able to then use the land for that purpose, should they be granted a license. Thank you.
Thank you. Thank you very much. I'll turn now to Mr. Rob Fippard. And just to reiterate, there are new points that would be really helpful. Thank you.
Yeah, so I'll maybe throw away everything I was going to say because everyone's covered it. So quick change. Would it be possible for a sense of scale if I could show you some images? It's quite important to us because it's
I don't see
going to
why not.
affect our lives quite dramatically if this goes through.
There are some rules on this. The licensing hearing regulations need to be complied with.
Chair, I believe that all parties need to be agreeable for additional evidence to be shared at this stage.
Okay, I stand corrected. So we would need agreement. So I would need to seek some clarification.
Within Mr. Fippard's representation, any sort of visual images were restricted to a bird's eye view of the area relating to parking and parking concerns, which obviously were explained couldn't be considered. So I think it depends on what point Mr. Fippard was trying to raise here as to whether it may be agreeable. The images that I've seen there, Jodie, from you wasn't part of the representation, but it depends what it is about, really.
Because I was worried that I wasn't going to be able to cover the points that I planned to cover today, I asked Rob to take this photo, which was on my letter. It's a photo showing how close the church is to our house, because when I corresponded with a couple of people about it and said that our house backed onto the outdoor area, the outdoor dining area, and how close we were to the house, the licensing officer didn't believe me. And so the first photo was on my representation. So then I added labels for the second photo so that people can understand how close our home is to the dining areas and the smoking areas.
So if it helps, we're not disputing where the property is or where the residents are, and there is no smoking area.
Just to clarify then, you said the first photo was on your representation, but I have 3 images in front of me. So
The second one is just the same image with labels. And the third image is new and shows our house from the tables, but he said he didn't object. So would it be possible to keep this in?
I think he said he didn't dispute the proximity of the house, whether or not.
Well, we're
object
trying
to
to
the
prove that we
images.
are actually, it's actually a residential neighborhood, which is, he keeps calling it a high street location and it's not. West Hill Road, which backs onto the church, is 100% residential.
Just bear with me one moment.
Yeah, I'm just checking on the system, but I'm not aware of all of these images. But my purpose, I suppose, is what's the purpose of presenting those images and the point behind those images? If the point is that it's a residential area, which I understand what you're saying there, Mrs. Flippard, the Licensing Act cannot consider whether an area is residential or otherwise when coming to the determination of a licence. If there was the cumulative impact policy, which there isn't, that may take into account the number of licenses in an area, but the Licensing Act cannot consider or refuse a licence based upon an area being residential or otherwise.
Okay, yeah, I've taken advice. We appreciate, you know, the pictures are relevant, but in regards to the determination of this particular application, this license application, I feel that those images cannot be distributed and used around the table. So
Sorry, I don't understand why. I don't
do you
understand.
want to clarify?
Yeah, that one works. There's no dispute of the understanding of the area. The application is for the premises that's on Birmingham Road. We appreciate that you live on the road immediately behind, and it's very clear to everybody that you have concerns that your residential area is in the close proximity. However, these images labelled, they are new into here. Not everybody has had the benefit of seeing them. You can speak to the content of them, but it's not required and also not appropriate to introduce late evidence at this stage that hasn't been considered by everybody else. If your first image, as you said, was submitted in with licensing, then as Mr. Batchelor said, actually the surrounding area is not a matter that can, in that respect, be considered within the licensing. It's the immediate vicinity. Isn't
That it's residential?
as Mr. Batchelor clarified a minute ago, determining whether the area is residential or otherwise is not a factor in here. But also the key point here is these are new images that hadn't been presented before the hearing today, and therefore it's not appropriate to introduce. We wouldn't allow the applicant either to also bring to the table information that nobody had had the benefit of receiving beforehand.
We're not trying to do anything underhand.
Not at all, no. No, and you can speak to those images and therefore the impact that you feel that the premises will have on your residential area. You can speak to those.
She said we can speak.
You can speak to them, and this is your opportunity to do that now, but
Okay.
the visual representation is
Okay.
thank you.
Sorry, just before you proceed, just to clarify, Councillor Adams has taken a comfort break. He'll be back very shortly.
Yeah. So,
I think we should wait.
we'd like, the committee
Yes,
to,
so if we could just pause the meeting there until
Right.
councillor Adam.
well, you wait for him to come back.
Actually, what I would do, I will call a 5-minute recess if that's okay. So 5 minutes, thank you. 11:55, thank you.
In 5 minutes. Gonna get changed and come back.
Yeah. Because you're going to stay here.
I have to use the ladies.
I'll wait here.
No, you can't. That's more important. Just, that's okay. I'm really stressed and
Okay, thank you. Now, I am aware that Mr. Fippard is renewing the parking ticket, but if we could proceed, but I must be very, very clear. I must be very, very clear that it's fruitless and we don't want a repetition of the points already made. So if we could keep it succinct and to the point as possible, I'll be really appreciative. We need to make a decision on this.
Am I able to clarify points that were made by the solicitor? Is that, for example, am I able to speak about things like the outside tables being cleared after midnight, which residents weren't aware of? That was new to us, so we wouldn't have been able to write to licensing about it.
Certainly make those comments, and I can always include that with the officers with the summing up, without a doubt. Yeah.
So that's, I actually couldn't hear you well at all. But the few things that I picked up were quite alarming. For example, I go to bed early. I get up early, go to bed early. So the hours of midnight to 8 are a bit artificial if those don't happen to be your sleeping hours. You're making a face, but not everyone sleeps in the hours your restaurant's going to be closed. Some people go to bed earlier, get up early, and then some people even sleep during the day. And you said that they were going to clear the tables after you close, which is after midnight.
Can I
Could you
clarify?
please clarify?
Yeah,
the
so I'm sorry if you couldn't hear me. I thought the microphone's pointing that way, but I assume. Oh, I'm sorry. I'll try and speak a little bit louder. We will be closing the outside area at 10 p.m. every day, which means that nobody can use the outside area after 10 p.m. including for smoking.
But then you won't be moving the tables indoors, you said, until after the restaurant closes. You said you couldn't move the tables. So we'll be hearing, if we manage to stay awake till 10 so the outside noise is finished, then we're woken up again after midnight when you're clearing I don't mean clearing the tables, clearing the cutlery. You're moving the tables away after midnight. You said you couldn't do that until the restaurant was closed.
Yeah.
With the greatest respect, if you make your comments now, and if you direct that towards me, please, and then when we come to summing up, that will be covered at the end.
So I'm just very concerned about not being able to sleep. And I was going to speak today about the effects of sleep deprivation on physical and mental health. But I get the impression that that wouldn't be, relevant to licensing. So I'm not going to talk about that. But the solicitor also mentioned the phrase high street location many times. It's not a high street location. He also said that their customers wouldn't smoke, which I think is an absolutely ridiculous thing to say. A lot of people do still smoke and vape, and I'm not allowed to show the photograph, but if the people can't, the licensing application says that the patrons will be allowed to leave the premises to smoke outside. So they won't be able to do that in the outside table area. So that leaves the default area for smoking will be the alleyway down by our house. So that could go on potentially as late as midnight if people are allowed to step outside to smoke. And you can't say that your customers are so wonderful that they don't smoke because they're just customers. And you also made a comment about you're not the Duke of York. Well, the Duke of York has late opening hours, but they choose to close at 11 o'clock because of their consideration for their neighbors. And some of the neighbors have Sally's phone number so that if it does get a bit loud, they call her and she turns down the volume. So I think the Duke of York is a very well-managed pub. And I don't think that you can say that your customers won't be noisy or they won't smoke. It's just unrealistic to say that. I guess I'm finished because, yeah.
Thank you very much. Thank you, Mark. Again, so just to reiterate, if we could have new points, not repetitive points, that'd be really helpful for us. Peter Morton.
Well, I live at number 11 Birmingham Road. My daughter with 2 young children, aged 3 and a year, lives at number 13. So far, I believe most of the people to the left of me are West Hill Road residents, if that's correct.
Yeah.
I feel that most of what's been said, most of the objections have already been rehearsed. We had some fairly strong rejections from Mr. Batcher on the emails that both my daughter and I submitted to him. Despite the fact, I still believe there is a public nuisance issue with this application. And for the gentleman here who made the presentation, consistently referring to the place as a high street, it's not the high street, it's Birmingham Road. And there's a distinct difference between Birmingham Road, and the high street. Most of the party, and I think whatever else happens, and despite the applications, the assertions from loungers, this is bound to turn into another party house venue in Cowes in the same manner as most of the clubs and restaurants, and most of the pubs and restaurants in Cowes are used for that purpose. And as Susan said, yachties are quite noisy and tend to stay up late. And I don't believe it's going to be any different here than any of the other establishments in Cowes. And this is not in the high street, it's in a residential area.
Thank you. Thank you, Mr. Morton. Okay, so just to be very, very clear, if there are new points, we're happy to listen, but we cannot have a repetition of the objections already made. Thank you.
Right, I've lived there for over 30 years. I remember when there was a police station on the corner. It's no longer there. It's the antisocial behaviour that occurs. Over the years, it's gone up and down. Since COVID's kicked in, the noise levels have dropped because people don't go out like they used to before COVID or since COVID. Now things are picking up. I think the footfall will increase. People will start to use that venue as a position to get some extra drinks in on the way home. They will congregate, they will use it as a stopping position before they go to the floating bridge going back towards East Cowes. We're sitting here in the daylight hours. During the daytime, we're all being nice and polite, but at 2 o'clock in the morning, it's different. It's dark, the lighting is insufficient. Where we live, things get heard, things get said, things don't get reported. So the antisocial factor, if you phone the police up and ask and say things are being antisocial, their response time should be a lot quicker than if they say, oh, I think something's happening, the way you word things. So my concern is the antisocial behaviour that will increase, the noise will increase. It's going to be worse for people that live backing onto the premise. I don't believe they say that the tables will be put away, but from a performance point of view, in these establishments, the staff in day, when you're not there, they will start to say, we're going to earn an extra £500 here by just keeping them tables over for an extra 5 minutes, an extra 10 minutes. They're busy doing things. The person that's supposed to put the tables away won't be putting the tables away because they'll say, we've got bums on seats, we're selling booze, and they'll say, profits look good. So the company will say, we're quite happy, that 5 minutes will become 10 minutes. The license in the future might get altered and tweaked, and booze could be sold till whatever time. So my point of view is when I'm lying in bed, if I'm hearing things going on the street further down, it can be quite, what's the word? Quite disturbing. Some of the things that we hear in the streets is not what you hear in here. It's not what the police hear. And so that's my concern.
Thank
Okay.
you for your comments. I'm trying to be as fair as I can, so if you have comments that have not already been amplified, I'm quite happy to hear them.
Oh, let's turn that one off.
Richard Hargreaves. First of all, I'm speaking on behalf of Rebecca Block, my partner, who owns the property next door to Darien, which is number 40 and 42 Birmingham Road. As a technical point, I've seen in the application that the Methodist Church is also, well, apparently 40 Birmingham Road. Seems slightly odd, but certainly an administrative problem of mail in wrong places and a recording of the wrong premise. I'm also here as Commodore of Cowes Corinthian, which is directly opposite the proposed venue. And our concern is we already sometimes have people wandering into our club because they've bought a meal at Darien and wandering down to use tables and chairs. We have the water right next to us, and people who are over merry and looking for somewhere to have a pee is not good, safe near water. I was rather surprised by Mr. Batcher's reply to us that security was our problem. I'm not sure where drowned bodies come in their responsibility, but certainly that whatever happens in this sort of situation, there are more people and more people who are spilling out of the premise. And even though the licensing authorities say they can't be responsible for that, they are still in the area and still causing problems and nuisance for the people of the area. I think that's all I need to say.
Thank you for your comments. Okay. So I will now turn to the responsible authorities to sum up. And obviously there may be a lot of issues or maybe a lot of queries and questions that you may want to. As regards to Mr. and Mrs. As regards to Mr. and Mrs. Fippard, I've been more than fair. Normally if there's two from a couple, then only one speaks. I've been more than fair on that regard. Again, sir, if it's a repeat of any of the objections already heard, we really can't take those into account. So,
Mr. Chairman, I appreciate that. Thank you very much. I do apologise for my my departure for parking requirements, which is an issue. But anyway, thank you very much for the time to enable me to speak. Slightly out of breath, having run up the stairs. And I'd like to thank Mr. And I didn't quite get your surname, Botkai,
Okay, but Robert is fine.
Robert, thank you very much for his words and his explanation. Although I do believe on a very personal set of opinions from what he was saying, especially the relevance associated with his visit to the premises last night, which was a Wednesday in quiet September and is not necessarily representative of the high season in Cowes when such an establishment will draw a significantly more rowdy clientele. I would also question his assertion that this location is High Street. It is not High Street. This is Birmingham Road, an area outside of the High Street where, and I know we keep coming back to this, it is a residential area, a quieter area, which I personally believe will be impacted significantly by such an establishment who Robert claims to be a family drinking establishment and eating establishment, but I would question what family goes out to eat and drink until 12 a.m. and even later on certain requested times that on a special license, 2 a.m. on New Year's Eve. So this is what the basis of my objection. Why do we need such late licensing? Why do we need an additional location in what is predominantly a residential area? Sorry, I haven't been able to coordinate my notes terribly well, and I'm still out of breath. But thank you very much for your time and allowing me to speak.
Thank you. Thank you so much. Okay, so I will now turn to the responsible authorities to sum up, please.
From myself, from when I did the initial checks before granting, putting out to what conditions I would expect, I had a look at the hours of the local establishments in the area, which fall into the Duke of York can serve alcohol 24 hours a day to residents, and from 6:30 in the morning until 1 o'clock for anybody else at the premises. Again, not a part of it. The Chinese can stay open till 1 o'clock. The kebab shop can stay open till 2:30 in the morning. Can. It's not necessarily they do, they can stay open till that time. And Cowes Corinthian can stay open till 2 o'clock in the morning as well. So again, there's a lot of open areas. So that's why when I look and they go, we're going to do till 12 o'clock, I'm happy with those conditions that I've put in place. On the noise side of it, I have walked past the one in Newport, I do not know how many times, and I've never heard them playing drum and bass. I've never heard loud music coming from it. Yes, if I walk past when somebody opens the door, I can hear the music, but again, it is at background level. So I would support them on that side of things. What's that? I would, again, you could class that as not part of the high street because it's along and it's quite a residential area along that side of Newport with, again, lots of establishments, lots of shops, exactly the same as Birmingham Road is, where it's got shops all the way along the bottom. So again,
with the greatest respect, please. Yep, thank you.
So again, different areas, different reasons, but again, nothing else that I can say on from what I've previously already said.
Thank you. Mr. Powell.
Thank you, Chair. So I feel it's worth reiterating that the decision made today even does not relieve the applicant of the need to apply for planning permission. Again, that's outlined within Part 8.97 of the Section 182 guidance issued under the Licensing Act, and it's very important to note. On 4 issues that have been raised by local residents, those being mechanical plant noise, artificial lighting, odour and patron noise. So for instance, the mechanical plant noise, in respect of a planning application, it's likely to require a noise impact assessment based on very robust methodology in line with BS 4142, which effectively will assess potential adverse impacts on local residents. So that's quite lengthy in terms of what's required. In terms of artificial lighting, that's covered by the statutory nuisance regime. And again, this will be assessed in respect of amenity in relation to a potential planning application. In respect to odour, it will require an odour risk assessment and consideration on top of that of abatement technology were the risk assessment to indicate further abatement is necessary. And on patron noise, there is no shared methodology in terms of how you assess patron noise. However, I understand the applicant is likely to put in a noise management policy providing additional controls further to the hours which have been put forward. So to confirm, the planning process provides an additional means of scrutinising the matters that quite rightly have been mentioned by local residents today, but we also have the addition of the statutory nuisance regime, allowing for additional review of any complaints were they received subject to a successful application. Thank you.
Thank you very much. Mr. Botkar, it's your opportunity to sum up, please.
I think I go last. So it's one of the very rare occasions in my life where I get the last word. So I'd appreciate. Is everybody else finished?
My apologies.
Thank you, Chair. Yeah, obviously many points have been raised today, and obviously all of them acknowledged, but as we've indicated, there are many of them that can't be considered when determining this application from a licensing perspective. So such references have been made to, with regards to other similar premises at other locations, both on the island and on the mainland, throughout the UK, and how they're managed. Although the manner in which operational processes, procedures and incidents they've been highlighted today for other licensed premises, they can't influence the decision made by the licensing subcommittee in relation to this application. So how another premises has been managed, either well or not so well, wherever that premises may be, all of that you can't be influenced by those sort of comments, just for that point to be made. Members are also reminded that issues raised around parking provision, location, and whether location, i.e. residential or not residential, and whether something is needed or not, in someone's opinion, cannot be considered either when you're determining this application. Behaviours of other persons once they've left the immediate vicinity of the licensed premises, and that's either within the premises itself or outside of the direct outside area of that premises. The behaviour of those persons are for them to decide how they behave and not the responsibility of the licence holder. So that the licence holder cannot be held responsible for people's behaviours once they've left that immediate vicinity. After considering all the available information prior to and during the hearing, it is still the view of the licensing authority that the granting of the premises licence with agreed conditions is not likely to have a significant impact on one or more of the 4 licensing objectives. In addition to this, the licensing authority takes the view that the conditions agreed between the applicant, environmental health and the police, as well as measures that the applicant is committed to within the operating schedule, which will be converted into enforceable conditions should the licence be granted, are both proportionate and appropriate when considering the nature of the business, inclusive of the times and the activities that are being proposed by the applicant. It should be noted, though, that those persons that have made representations and that authorities such as police, environmental health and licensing are able to exercise their enforcement powers on a licensed premises should complaints be received and substantiated following investigation of such allegations. In addition to this, the Licensing Act legislation contains provisions where an interested party can apply for a review of a licence at any time. So members should determine the application in accordance with Section 18 of the Licensing Act 2003 and the Licensing Act Hearings Regulations 2005. And just to reiterate, the options open to the committee today are to grant the licence as per application, to grant the licence with agreed conditions, as well as any additional measures that the licensing subcommittee deem appropriate and proportionate to promote the 4 licensing objectives, or to refuse the application. Thank you.
Thank you. Thank you very much. This is the opportunity for the residents to sum up if they've got any further brief comments, please.
Thank you. I don't speak on behalf of anybody else here because that wouldn't be professional of me. I'm not engaged by them. So I only speak as a private citizen. But I think the points which I've already made to you don't get any better by repetition, as I agree with the chairman on that respect. But I would ask you to look at each and every one of them in your deliberations as to whether or not to grant this licence. And also there is some disagreement about the law. I've made my points, Mr. Batchelor has made his, and it's for you as the licensing committee to decide which decision you're going to make on the basis of that. But there is a valid point about Mr. Batchelor has taken the point that, oh well, the previous case I referred to him was in where there was a cumulative impact policy. But that doesn't mean to say that the committee can't consider the nature of the immediate area around the licensed premises, which in this case is residential. I mean, there are 2 takeaways, but apart from that, it's pretty residential. So I'd ask you to look at that and consider that as well. And also whether or not this is a decision you should make before you have a the outcome of a planning application. You do have the option of adjourning it pending the outcome of a planning application, and you also have the option of looking at the restrictive covenant aspect. I know you don't particularly want to deal with that today, but it is relevant because if you make a decision to grant a license, and that decision, as you sit as licensing justices, in breach of a covenant binding the land, then that could be challenged as being unlawful, in which case it probably goes somewhere else. Thank you very much.
Thank you. Are there any other brief comments from residents? We need to be brief, please.
So I'm looking at the committee report, section 2.15, and I respectfully ask the committee to focus on the effect the licensable activities at this specific premises on persons living and working in the area around the premises, the issues of noise nuisance, light pollution, noxious smells, and litter. Thank you.
Thank you. I will now turn to the applicant to sum up. Thank you.
Thank you. And these hearings can be emotive, and we are not belittling in any way the concerns that residents have about what may happen in the future, but there is a certain amount of crystal ball gazing on their part and imagining and fearing the absolute worst case scenario. I'm sorry if I've got some of the names wrong, but Mr. Miller is concerned that the premises, if we secure the license, it'll be handed over to hardened drinkers with heavy rock and thumping bass coming out of the premises. But he acknowledges that he's not been to a lounge diner before. Fortunately, PC Buchanan has many times and has confirmed that he didn't hear such music from the premises, and that's because we don't play loud music at any of our venues, and we won't do so here. So we're told that, I think Mr. Morton, that this will become a party house. Well, it won't become a party house. It will operate as all our other lounge premises do, as a lounge family diner. I didn't say that only families would frequent the premises, of course not. But that's the theme. That's how we operate. Mr. Shelley is concerned that drinkers will use the lounge on their way home and to secure another drink. Well, generally, people don't come in to a lounge just for a drink. There are other places that they can do that. For example, they could go to the Duke of York to get a drink because they can be open longer hours. I respect if they close at 11 p.m. That's their choice. We may close at 11 p.m. as well, exercising the same choice. Mr. Shelley is also concerned that we will extend our license. We'll just get bigger and bigger and later hours. If we so much as seek a variation of 5 minutes, that would require what's called a major variation of the license, and that follows the same process as we've just gone through with the new license application. And I know you know, as a committee, I'm saying this really for the benefit of the room, that blue notices would go up for 28 days. It would go in a local newspaper, and residents would have the opportunity to object, and of course officers as well. So we can't, if you are minded to grant the license as we're seeking today, it's not a simple matter for us to just come back and extend those hours. I'm sorry if I've caused any confusion by referring to High Street. We were there last night. We have a takeaway one side. I think it's the Chinese takeaway on one side of us and a takeaway on the other. It feels like an extension of the High Street. So I didn't say, I'm not saying it's the High Street. I'm trying to explain. I didn't mean to infer that it is the High Street. Susan Brown has made a number of points, and I do need to come back on these because it's important that you as a committee are not misled in any way. You are not sitting as licensing justices. You are sitting as councillors on a licensing committee. So I'm not quite sure why that's been repeated 2 or 3 times that you're sitting as licensing justices. There was a veiled threat. I don't know whether you picked it up at the end that you could be making an unlawful decision and that it could go somewhere else with the precise words. I don't think that's language that should be used by council, whether in private capacity or professional, in a hearing before a licensing committee. And you shouldn't be concerned about the threat of going somewhere else, by which I assume Susan means a judicial review or High Court. So you consider your decision as committee members, as councillors, based on the evidence that you hear before you today. Just to be absolutely clear, there is no breach of contract if you grant this license, because there is no contract. I've tried to explain there is a document from 1888 which has got some blanks in it. It's difficult to fully understand who benefits, who's got the burden, and whether it's enforceable, and whether the wording of that covenant that applied in 88 would apply to a diner such as ours in 2024. I don't know the answer to that, and with the greatest respect, you, the committee, we could be here all day and you wouldn't be able to answer that question. That is a matter for somewhere else. That is a matter for somewhere else. If anybody pursues that, but it's not part of today's proceedings. So it would be wrong to say, completely wrong to say, that the grant of this license would in any way be unlawful or condoning some sort of breach of contract. So I do wish to be very clear on that. There's been discussion about whether this is a residential area or not. And I think Shane tried to clarify that it doesn't really matter for the purpose of this application whether it's residential or residential and commercial or simply commercial. And we have numerous lounge premises which are actually the ground floor of blocks of apartments. So it's not unusual for a lounge diner to be in amongst the in a residential area. So that's again not something that we have to determine today. There's the concern that the mainland is different. Well, we have a lounge here, and I understand that we're not looking at what other venues are doing as such, but it must be relevant that you consider how a lounge operates, because that's the basis of our application, that we're not a vertical drinking establishment, that we're very different to a pub. Again, Susan was wrong, I believe, to say, unless she has better information than me, to say that the Duke of York has no off sales. I'd be surprised by that, because almost all pubs, certainly before the Licensing Act came in, had just as on and off licenses. So most pubs could make sales for consumption of alcohol, for the sale of for consumption on the premises and off the premises. And I would be extremely surprised if the Duke of York didn't have that facility. It's probably not used very much, in the same way that our off sales wouldn't be used very much. And thank you for the clarification that their license is to 1 a.m. So the decision today must be based on actual evidence, and the problem always in these hearings is that we're looking for something that is going to happen in the future. So you need to determine based on the evidence, and we have the evidence of how we operate elsewhere. You've got your experts who are the police and environmental protection, who are not just satisfied with the application, they've attended today to express their satisfaction for the application. That is highly unusual, and on behalf of the applicant, we're very grateful that your officers have taken the time to come and address you today and clarify some of the issues. Susan also said that a review could be more difficult and now is your opportunity to refuse the application. I would completely disagree with that. On a review, you would have evidence before you. This happened at this time. This happened. I was walking my dog, and I was disturbed, or we couldn't sleep, or the noise of bottles. So you would have real evidence
on which to make a decision on a review. I don't expect that to happen. It's not our experience elsewhere, but that's how the review process works on evidence as to what actually happened. I think it's Mrs. Fittard who, again, apologies if I got the name wrong, referred to the Duke of York as being a well-managed pub. Well, we will be a well-managed diner. And she also has a telephone number of Sally. I don't think we've got a Sally, but we do have a Kaylee. And following the proceedings today, we will swap telephone. We'll certainly will. Absolutely. Yeah, I'm very good at giving Kaylee's mobile number out. And I've done it before, so without even taking instructions, yes, Kaylee will be very happy to provide her mobile telephone number. Can I just finish by saying, I understand the tension, I understand the concern, but we wish to work with our neighbours, and we're very happy to meet with them in the build up to our opening, if we are granted the license, if we are granted planning, and we will build the relationship with them. And I very much hope that they will become our customers and enjoy the facility that we'll be offering. Thank you.
Thank you very much. Are you happy to answer that?
Yes, yes.
Just very briefly.
Yeah.
And we could.
Yeah,
we could stop it there. That'd be great.
Of course, no, I understand. We can invite you to, for instance, we'll provide contact numbers. We're very happy to hold regular meetings with our neighbours at the venue, so that you can come and discuss any issues that you may have with the operation. So we will be very open, and again, we can provide contact details. Thank you.
Thank you.
Clarify one thing, I didn't make
We could be going on forever.
I'm really,
No, no,
yeah.
but he
I'm
mentioned that
no, I'm really sorry. We
fell
have to
threat, and I
move
think
on.
that's not the
We
case.
have to
Thank
move
you.
on. Thank you. Thank you. Okay. Yeah. Okay, so there's no other comments with regards to summing up. Okay, so on that point, the subcommittee will now retire to deliberate on the application and make its decision. So if you just bear with us, we'll be back to you as quickly as we possibly can. Thank you. Thank you for your patience and your indulgence. I will turn to Jodie Gibson to read out the decision of the licensing committee.
Thank you, Chair. Upon receiving the report of the licensing section, the oral and or written evidence from the applicant, the responsible authorities and other persons, and having regard to the guidance issued under Section 182 of the Licensing Act 2003 and the Isle of Wight Council's Statement of Licensing Policy, the subcommittee hereby grant the licence in accordance with the application, subject only to those conditions proposed by the applicant within the revised operating schedule, and also subject to the mandatory conditions specified in the Licensing Act 2003. In reaching the above decision, the subcommittee have had regard to the Human Rights Act 1998, and in particular, Article 1 of the First Protocol, Article 8 and Article 6. The subcommittee consider this decision is proportionate and appropriate for the promotion of the 4 licensing objectives under the Licensing Act 2003. There is a right of appeal to the Magistrates' Court if anyone is dissatisfied with this decision, and any appeal must be made within 21 days of the date of notification. Thank you.
Thank you very much.